Hello, and welcome to Gateway to Privacy, a podcast from global law firm K&L Gates, where we discuss the latest developments and best practices in today's data protection, privacy, and security industry. We hope you enjoy this discussion. Please reach out to suggest topics or guests, or with questions about data privacy law.
Welcome to the Gateway to Privacy podcast. Today, your hosts are Whitney McCollum, a partner in the K&L Gates Seattle and San Francisco offices, Amigo Xie, a partner in the K&L Gates Hong Kong office, and Corey Bieber, a partner in the K&L Gates Chicago office. We are all technology transactions attorneys. Whitney and Corey are certified privacy professionals, and Amigo is a PhD in PRC law. Hi, Amigo. Hi, Corey.
Hi, Whitney. Hi, Corey.
Today, we are talking about data transfers, and specifically transfers of personal data from China to another country and the background and restrictions around those transfers. The China Standard Contract took effect on June 1st, 2023, as well as the other transfer mechanisms. So it's imperative that any company that is transferring personal data outside China understand their risks and their obligations. Amigo, can you give us an overview of China privacy law right now?
Sure. And actually, the China data privacy region covers personal data and non-personal data, And there are three basic laws in China. The first is cybersecurity law. And from the name of the law, you may see that it focuses on cybersecurity issues. The second is the data security law. And also, from the name of this law, you may see that it focuses on data security issues, especially non-personal data. And the last one is the personal information protection law, and it focuses on protection of personal data. And all the three basic laws are effective now, and it's the fundamental structure of the data privacy protection regime in China.
Thanks, Amigo. And so with respect to data transfer outside of China, what is the basic premise? Is it that personal data cannot leave China, or is it broader than that?
There is no such a strict localization requirement in China. However, to transfer personal data from China to other jurisdictions, three mechanisms should be followed. The first one is National Security Assessment. We call CAC assessment. CAC refers to Cyberspace Administration of China, CAC assessment. This is the National Security Assessment. The second mechanism is with third-party protection certificate. It's a kind of certification made by a licensed institution. And the last one is China SCC, China Standard Contract.
Thanks, Amigo. And so there's three ways to lawfully transfer data out of China. And can you clarify, is it just personal data, or are there other categories of data that are subject to the data transfer requirements?
In terms of the China Standard Contract, it's about the personal data only at this stage. But according to a draft regulation, and the three mechanisms, it's possible the three mechanisms will apply to non-personal data as well. Especially the CAC assessment currently applies to transfer of non-personal data from China to other jurisdictions already.
That is really helpful. Thank you. And so can you break down the three cross-border transfer mechanisms? Because I understand from what you have already taught us here, it's not an or, which is what the GDPR transfer mechanisms are. You get to pick. Here, the CAC assessment has a threshold, I understand, and the standard contracts and the Institute Protection Certification have different requirements.
On the one hand, we say there are three mechanisms, but on the other hand, they are twofold. There are not three options, because as Winnie, you mentioned just now, the CAC assessment, the National Security Assessment, is mandatory if it's triggered. And the threshold are the conditions to access whether a CAC assessment is required. The first is if the data controller in China if the data export in China is a critical information infrastructure operator, CIO, any transfer of data by the CIO from China to other jurisdiction is subject to the CAC assessment. The second is if the subject is the important data or core data, any transfer of such data from China to other jurisdictions is subject to the National Security Assessment, the CAC assessment. The third one is we call large-scale personal controller. It means that if a personal data controller handles more than 1 million individuals' personal data in China, any data transfer by this kind of personal data controller from China to other jurisdictions is subject to the CAC assessment. The last one is we call large volume cross-border data transfer. It means if a data exporter, data controller in China transfer more than 100,000 individuals' personal information or 10,000 individuals' sensitive personal information from China to other jurisdictions over 2 years from January 1st of last year, any personal data transfer from China to other jurisdictions by this data controller is subject to the CAC assessment. So it means that if a cross-border data transfer from China meet any of the 4 conditions, no choice for both parties in this scenario. They have to go through the CAC assessment. When only on all the conditions are not fulfilled, it means that the parties to the cross-border data transfer may consider China SCC or the third-party protection certificate.
Can you also describe when the China SCCs are used versus the protection certificate? Because I understand those are also not necessarily an or, and we'll get into the situation with you and Corey where you handled this for a client and both applied based on different types of processing done by a company. But I think it's helpful to lay out when those come into play if the CAC is not triggered.
I think this is a good question. I think this is relating to the major differences between China SCC and GDPR SCC. First of all, the China SCC, under the GDPR data protection regime, the GDPR SCC applies to 4 models. That is, from controller to controller, we call C2C transfer. The second is controller to processor, C2P transfer. The third is processor to controller, P2C transfer. The last one is P2P, processor to processor transfer. However, the Chinese data controller must be a party to the China SCC. And so it means that if it's a P2C transfer, if the personal data is not collected from China, the China SCC cannot be used in this scenario. And in a P2P transfer, also, if the personal data is not collected or generated from China, it looks like the China SCC cannot be used either. And for this kind of P2C or P2P transfer, the third-party protection certification could be used. So that's the difference between the 2 options if the CAC assessment is not triggered.
Thank you. So yeah, I think what's really important is there's 3 ways to transfer data outside of China, and you don't get to pick. It depends on the amount of data, the category of data, and who is sending and receiving the data. So, Corey, you work with a lot of global clients. I understand this issue has already come up for you, and you and Amigo worked together recently on data transfer for a client in the US. Can you describe the scenario?
Sure. So I represent a large academic research institute, and while all of this was transpiring in terms of the new Chinese data protection laws, et cetera, the client was in the process of offering its courses in China, and they had 2 different approaches that they were trying to take to do this. On the one hand, they were partnering with Chinese universities to bring Chinese students to their U.S. campus. And this was complicated in that the universities had already shared personal data with my client, and they were continuing to do so without a transfer mechanism in place. So we had to act fast in that case. The second issue was the client was offering an e-curriculum to Chinese students while the students were in China. So essentially, the student in China would take the course that was hosted in the United States. And naturally, I reached out to Amigo, and he can fill you in on the details on how we address these relatively novel issues.
Thanks, Corey. Amigo, can you share with us how you and Corey worked together and how you advised on how to address these issues?
Sure. I think the two scenarios, the two options are typical examples for us to understand how the three data transfer mechanisms in China work. First of all, as I mentioned just now, in the first option, it's a personal data transfer between a Chinese university to an entity in the US. So first of all, we need to assess whether the CAC assessment, national security assessment, will be triggered. And we need to check, for example, whether the data export is a CIO or whether the threshold, as I mentioned just now, the amount of the personal data has been handled by the data export, something like that. After we determine, okay, the CAC assessment will not be triggered, then the next step is we will consider which mechanism is better or easier or more efficient for the client to be part of the cross-border data transfer. And because in the first option, there is a China data controller, and the entity in the US is another controller, data controller. So it looks like the China SCC could be used, as I mentioned just now. If there is a China data controller, the China SCC is an option. And compared with the third-party protection certification, it looks simpler because it just depends on both parties' efforts. No need to engage a third party to issue the certificate. And while in the second option, the situation is different, totally different, because the entity in the US collects the personal data from China, from the data subject in China directly. So in this scenario, there is no data transfer from China. It's just a data collection from China and no personal data controller in China in the second option. So as I mentioned just now, it's impossible for the data subjects in China to enter into China SCC with the entity in the US. And if the CAC assessment is not triggered, it looks like the entity in the US needs to consider the third-party protection certification as a mechanism to receive the data from China.
Thank you. That's really helpful because it's one institute doing two different things, but all kind of within the same vein, but it's two different ways of receiving data and two different transfer mechanisms apply. And so, Corey, how did the Research Institute respond to needing to potentially create new privacy protections to comply with the standard contract, or at the very least, engage in a transfer mechanism that is really brand new?
Right. So I think in general, my clients have a visceral reaction when they see my name pop up in their inbox or on their caller ID. But in this case, seriously, this particular client was not entirely caught off guard. Despite the differences between the Chinese laws and the EU laws, the General Data Protection Regulation, many of the internal mechanisms that this client had put in place to comply with EU law, such as awareness within the contract department, information security controls, and rights request response, these carried over to the Chinese law. And although they thought of the thought of registering documents with the Chinese regulator caused heartburn, we're still working that out with the client to get them through it. Incidentally, going back to the first example I mentioned previously that Amigo described, when we reached out to the Chinese universities who our client was partnering with to discuss how the university would like to collectively proceed regarding the transfer mechanism, the Chinese universities had no idea what to do, which I believe will be the case for a while as we sort all of this out. Now, notably, this client, the institutional client, the research institution, was more sophisticated in terms of their compliance program. I have smaller clients that have struggled more because of the privacy concepts and controls are new to them. But we focus on practical solutions and we walk them through the process by addressing the areas that are greatest risk first. In the end, it works out. As I've always say to clients when they're faced with daunting data protection laws, the sky is not falling. We do have solutions and they can get through this.
I think that's a really good point. I'm laughing at the caller ID because I think as privacy attorneys, we're often saying, well, things have changed again. So let's talk about how we're going to, supplement your privacy program here. And I like that perspective of the sky is not falling, because it's not. We're this far into privacy now. We have the tools based on past laws and privacy compliance programs.
When clients hear about these laws, whether it's the Chinese law or other ones, they find out in the media or they find out from some consulting agency or whatever the case is that reach out to them. And, when it comes to the media, it's meant to be provocative. The title will say something, are you ready for the Chinese data protection law? Be prepared, this sort of thing. And they react to that. They react to it. But it's really about, from our end, it's really about working with them to understand what the actual requirements are, what they already have in place, as was the case with the Research Institute, and how they can leverage that to comply with the new law. And where they need to make changes, they'll have to make changes. So.
Yeah, exactly. And let me share one experience, especially actually, even we use the same name, SCC, but the documentation structure and some key points are totally different. There are some Chinese characters in the China SCC mechanism. First of all, our experience under GDPR SCC, we can have a commercial contract, and then we put the GDPR SCC as the supplemental clauses to the commercial contract. It's quite straightforward, right? This is the current practice. Well, the China standard contract is a contract. It's not a contractual clauses. So the requirement is, first of all, you need to enter into a contract. If you have additional arrangements relating to data processing, okay, you may put it in the exhibit to the contract. So you see the documentation structure is totally different from what we use with the GDPR SCC. Second, you cannot revise the provisions. You cannot revise the standard clauses in the standard contract. You can supplement it, but you cannot revise. And also, the supplementing provisions should not be in a conflict with the main body of the standard contract. So that's the second point. The last one is the China SCC must be governed by PRC law, and the dispute resolution should be either litigation in China or arbitration in the members of 1958 Nuremberg Convention. So it means that if the case is there is a data export in China and they want to sign the China SCC to transfer the personal data from China to the US or EU, you have to use China SCC, which is governed by PRC law, and you cannot use GDPR SCC in this context. But if the scenario is it's a personal data transfer from EU to China, okay, you may use GDPR SCC. So you see, if the case is a two-way personal data transfer, the client may need to consider use two contracts for each transfer.
That's really good to know, because I think, Corey, to your point, what we're advising clients on and what clients are managing is the reality of multiple privacy regimes. And the solution is make a privacy compliance program that contemplates each of them, that has a very strong foundation built on existing law and can just be flexible with the changes in the laws. And so with an existing privacy foundation that understands data transferring out of certain countries might be subject to different restrictions, the contemplation of data being transferred or being received from China now has these new restrictions is less Chicken Little, the sky is falling to a company than the media headlines. And I'm laughing because I know those, and we receive those calls, and it's pretty stressful when you're in-house and you're facing executive team and a board and a security team that's like, do we really have to change everything again? And so I think the approach of it's going to be fine. We have the tools and we can put everything in place. And so you can manage this is exactly the way to think about it. So I think with that, we've got a lot of really good information and some scenarios on this new transfer regime to get personal data and other important data out of China. Amigo Corey, thank you so much for your time today and for sharing your experience advising on the use of the China transfer mechanisms. That wraps up this episode of the Gateway to Privacy podcast. We hope you enjoyed learning about China's data protection regulations and how companies who transfer data outside China can do so lawfully. We'll see you next time.
Thank you for listening to this episode of Gateway to Privacy. To listen to past episodes and receive notices for new episodes, subscribe by searching Hub Talks, that's HUB Talks, in your favorite podcast app. Tune in next time for more data privacy insights.